It's 9:10 here, Big 550 KTRS, and we today are imploring Donald Trump's advice: buy American, hire American. So we have hired Greg Willard, who is an American treasure, if you will. He is a law professor at St. Louis University. He is our KTRS legal analyst. Good morning, Greg Willard.
Good morning, McGraw.
Oftentimes, you come in here with interesting topics. None more interesting than this case this week. Has a national bent to it, and that is Neil Gorsuch is sworn in Monday, takes the bench, and the first case he hears is right out of Missouri, and one that is confounding legal experts as to what to do. How do you split the baby in half? Explain to us this Trinity Church story, because this has a Missouri all over it.
It has Missouri all over it, McGraw. It's the Trinity Lutheran Church. It goes back to 2012. Missouri had a program for school playgrounds to encourage the school playgrounds to use recycled tires, and they would provide funds for schools to do it. Trinity Lutheran Church applied, along with 43 other organizations, was ranked 5th among the applicants,
Right.
And was turned down by the state of Missouri because the Missouri Constitution, we'll talk about the federal Constitution later, the Missouri Constitution prohibits the expenditures of state funds in aid of a church. And the state of Missouri concluded that they could not provide funds for the kids on the playground at Trinity Lutheran Church, so the church sued.
Okay.
They sued in federal district court and said this is a violation of the First Amendment to the federal Constitution and the 14th Amendment. They lost. They went
What's the 14th Amendment?
The 14th Amendment does a number of things, McGraw, but it specifically incorporates the Bill of Rights onto the states. So the First Amendment says Congress shall not.
Right.
And what the 14th Amendment serves to do is it incorporates the Bill of Rights and makes them applicable to the states.
Which basically says the state can pass no law.
Right.
Okay.
That's
Gotcha.
that's
It always seems the 14th is thrown in. They're like the 6th, the 7th, and the 14th.
Well, and the 14th is a very expansive amendment. A lot of people tend to think of the 14th as very narrowly tailored to the Civil War and racial discrimination, but it is a much broader footprint than that.
Okay.
So the church lost in the district court.
Okay.
They appealed to the United States Court of Appeals for the 8th Circuit here in St. Louis, and they lost there. To, I think, the surprise of a lot of observers, the Supreme Court agreed to hear their case.
Okay.
As you and I have discussed before, the Supreme Court only takes about 75 cases a year out of about 8,000 that they are requested to hear. Well, they agreed to hear it well over a year ago. No one knows why, but it has been delayed, and it is going to be heard, oral argument will be heard this morning.
So they set the calendar any way they want. They waited until they had the full complement of judges?
A lot of observers think that the court was waiting until they had 9 justices,
Okay.
and now that Justice Gorsuch
Right.
has filled that 9th seat on the far right side of the bench.
Got it.
They have a full complement of justices, and it will be argued this morning.
And just so we know, Judge Roberts, the Chief Justice, he can do anything he wants whenever he wants. He can schedule it, right? He's the Chief Justice. There are no rules. He can do anything he wants.
Generally, the chief has wide discretion in terms of the calendar. I think anecdotally, it is understood that he is not autocratic about that,
Right.
that he talks
Right.
to his colleagues. But I think generally the chief has significant influence as to the docket.
All right.
So it's going to be heard today, and we'll talk about the merits for a few moments, and then we'll get into this side issue that has popped up because Governor Greitens has now gone the other way.
Right.
So this morning, what the Americans will hear in the recording, which is released afterwards, is the state is going to say the courts below erred, and our constitutional right under the First and 14th Amendment, that right to the free exercise of religion was violated. Therefore, justices, you need to reverse what happened in the 8th Circuit and the District Court and stand up for our rights and the school kids at Trinity Lutheran Church. The state of Missouri is going to say...
Because the state of Missouri is defending its constitution.
Right. It is defending the ruling below. And the state of Missouri is going to say, absolutely not. We have a state constitution, and it prohibits expenditure of state of Missouri funds for in aid of a religious organization, and that restriction in our Constitution needs to be respected. And in addition, they will point to our friend McGraw, the United States Constitution,
right,
and they will say to, among others, Justice Gorsuch, it doesn't say infringe, it doesn't say impinge, it says a state may not prohibit the free exercise of religion. And we, the state of Missouri, aren't prohibiting Trinity Lutheran and the school kids. We're not prohibiting their free exercise of religion. We're just affecting it. And that affecting is not violative of the First and 14th Amendment, because the First Amendment incorporated by the 14th says we can't prohibit their exercise.
Okay. So a couple questions here. These earlier court cases that upheld Missouri's ban of this money, were they conservative? Were they liberal? What are those deemed?
I don't think either one. First of all, you have a single judge in Kansas City, a federal district court judge,
right, and
he or she probably ruled on a very straight legal question,
right,
and said, look, the First Amendment incorporated by the 14th, it doesn't say you can't affect, infringe, impinge, and this recycled tire program certainly doesn't prohibit the folks at Trinity Lutheran. The Eighth Circuit tended to agree, and again, I don't think there's any particular bias McGraw ascribed to the Eighth Circuit.
Okay, now let's start with Josh Hawley for a second. Josh Hawley, Attorney General. Josh Hawley has heard cases in front of the Supreme Court. His office would be perfect for this.
Oh, he's a former clerk.
Right. So why did he recuse the entire Attorney General's office from participating in this?
He had recused himself earlier in the litigation because before he became Missouri Attorney General, he had taken a position for one of the I think it was an amicus supporting Trinity Lutheran Church. And to his credit, he recused himself and a special Attorney General was appointed. A few days ago, Governor Greitens rescinded the policy. So that would put Josh Hawley in a very large conundrum in that he's going to have to defend on the one hand and oppose on the other. And so he said the office of Attorney General can't be put in that position. So he recused the entire office. The individual who had been acting as Special Attorney General simply accepted an appointment, which can happen in Missouri, that the Attorney General's office hires a private attorney, and that private attorney will be in the court in a few minutes to argue on behalf of Missouri. What was fascinating to those of us on the law side of the ledger was a few days ago, the Supreme Court, on its own, reached out to the state of Missouri and to Trinity Lutheran and said, hey, wait a minute. If the governor of Missouri has reversed this policy, why are we being asked to adjudicate this matter?
Right.
Isn't it moot?
Yes, because the state agrees that they can give the money to Trinity College.
Exactly. Governor Greitens has said, I'm going to rescind that policy and we're going to allow going forward.
Good question. Why?
So yesterday, both the state of Missouri and the church filed legal briefs with the court, and they both said, Your Honors, hear the case. Because, among other reasons, Governor Greitens or his successor could change the policy tomorrow. It has a significant prospect of being changed. Therefore, go ahead and adjudicate it. My guess is it is likely that the court will go ahead and adjudicate it. I don't think they'll dismiss it for mootness. But where we go from there will be fascinating to watch, McGraw.
Is mootness a word?
Mootness is a word, my
Okay.
friend.
Mootness.
It's one of those words that, like Ipsy Dixit. You know, there's some of these phrases in the law world, we just love it, McGraw.
All right.
And mootness is a word that we love in the law.
I'm writing that down. All right. Let me ask you this question, Greg Willard, KTRS legal analyst and world-renowned professor at St. Louis University Law School. If the court overturns the Missouri Constitution, wouldn't that be an activist court telling the state of Missouri what they can and can't do? This is in our state constitution, presumably passed by the voters of Missouri. Why is it that Washington, D.C. is telling the independent state of Missouri how they should or shouldn't spend their money? If the law is to be changed, why not go to the ballot box and have the Constitution changed, or have the state Supreme Court rule this unconstitutional? Why do we have to go to the feds? This is an activist court.
Well, two parts to your question there. Let me address each of them separately. First, activism, my friend, is in the eye of the beholder. Mm-hmm. And what the left wing thinks is an activist court one day, the right wing will think is an activist court on another issue another day. Mm-hmm. So I would not.
So you punt on that question?
Well, I wouldn't think, irrespective of how they come out, they're applying the United States Constitution to this question, and by applying it, are they being activists? No, I think my personal opinion is no. They're doing what they raised their right hand to do. On the question of well, can't we just let the voters of Missouri or the Missouri Constitution, Missouri supporters of this policy, let them decide at the ballot box or through the Constitution? The answer is no. To put it in very crass terms, McGraw, our nation fought a civil war on that issue, and the North won the war.
Right. Which started today, by the way.
Well, the memory of Fort Sumter lives.
April 19th, 1861.
But the point is that absolutely a core principle of the United States Constitution is that when there is a conflict between a federal constitution, federal constitutional right, mm-hmm. and a state law or a state constitution, and if they are in conflict and that conflict cannot be reconciled, the state law or the state constitution must give way. Mm-hmm. So if the court determines, activist or otherwise, right. if the court determines that this provision of the Missouri Constitution is unconstitutional because it violates the First and 14th Amendment free exercise of religion provisions, then the court is duty-bound to find that provision of the Missouri Constitution to be unconstitutional. What they're going to be wrestling with is the state of Missouri is going to say today, and our listeners will be able to hear it and read the transcript. They are going to say, because this is a constitutional issue and we have a constitutional right, you should apply the strictest of scrutiny to what the state of Missouri is doing here. And there's no basis upon which, with a strict scrutiny review, this policy can be justified to the kids at Trinity Lutheran School. The state, on the other hand, is going to say, absolutely not. If we have a rational reason, policy, right. Constitution, or otherwise, you need, as you were saying a moment ago, McGraw, what the state will argue is you need to respect that if there is a rational basis upon which to justify this policy. So it's going to be a very, I think, animated debate today in the mm-hmm. Supreme Court over strict scrutiny versus rational basis.
What happens the next time, and this is more of a question for Governor Greitens, but I'll ask you since you're sitting here, Greg Willard, what happens next week when a Muslim school and mosque wants the recycled tires for their playground, and the state says, sorry, we can't give it to you, you're a religious institution, and then they sue saying you gave it to Trinity Lutheran, why shouldn't you give it to us?
Very good question, McGraw, and that goes to the heart of what we just spoke a moment ago about your new favorite word, mootness.
Yes.
Is that that is why both sides said it's not moot and you need to adjudicate it. On the question of another religion's school down the street, that your question is a terrific one, and it points out the difference in the law between policy questions, as you and I have discussed, that's why we have elections, and constitutional issues. And if you look up in the mantle of the United States Supreme Court, there is justice, and she has a blindfold on, McGraw. And that is the principle that we would hope would apply on the constitutional question, the blindness of justice as to the specifics of a religion, the specifics of a party litigant before the court.
Can you hold through the break?
Sure can.
Greg Willard, ladies and gentlemen, is teaching you about the law and the word mootness. KTRS legal analyst and good friend of the show, Johnny Londoff Chevrolet. There's nothing moot about him. He is real. And you know what he did? He earned it. That's Greg Willard. He earned the title as KTRS legal analyst, professor at St. Louis University, talking about this interesting case about Trinity Lutheran Church. And, you know, all they want to do is have a little playground.
Just want to have the kids play and not cut their knees and elbows up while they're playing.
And the money that has been expended to get this to the Supreme Court, they could have had the world's greatest playground in the world.
Playground, build them a new school, McGraw.
Wow, it really is interesting. All right, so Neil Gorsuch, this is his first week. We were talking off the air a little bit. He has announced his presence with authority on the bench.
He sure has. He took the bench for the first time on Monday. The Supreme Court is an institution that is steeped in tradition and protocol. So the junior justice takes his seat as you're facing the bench on the far right. And as justices leave and new justices are appointed, they switch their seats. He took his seat on the right Monday morning for the first oral argument. They had two that morning. And he asked 22 questions.
Which is, oddly enough, more questions than Clarence Thomas has asked in his entire time on the bench.
Justice Thomas is not a prolific questioner at oral argument, but it is interesting. Now, on the one hand, Justice Gorsuch asked 22 questions, which reportedly is more questions than any of his 8 brethren asked in their initial oral argument. On the other hand, yesterday, there was an oral argument, and he asked a sum total of 0 questions.
So they got to him.
So no, I don't think so. But today, I think with the likely exception of Justice Thomas, we should expect in this Trinity case, McGraw, a very lively back and forth at the oral argument.
Lots of people will take the questions and superimpose what they think they're going to vote because of the type of questions they're asking. Is that a legit deal? I mean, I know it's a parlor game, but how often does the questions they ask correlate to their opinions when the case comes out?
Sometimes. I think oral argument has a lot of functions. One of the functions is for the justice to get clarity of issues that are bothering him or her. It also is the opportunity for, in effect, the justices to communicate with one another as to their thoughts and to probe. But I think history shows us, McGraw, that to engage in the parlor game or to make a Las Vegas book on the basis of questions asked is a high risk to the point of folly proposition.
Do you know Neil Gorsuch at all?
I do not. I do not.
One of the few.
Read lots about him, and as you and I have talked on the air in other contexts, you look in the dictionary under the phrase qualified to be on the United States Supreme Court. I think Neil Gorsuch's picture is right there.
Yeah, no, that's a great point. Is it Gorsuch or Gorsuch?
Gorsuch.
Thank you very much. You are correct, because that's the way he pronounces it. Clarence Thomas, you know, I agree with Clarence Thomas when he says, look, I don't need to ask any questions. It's all in the paperwork. If I have a question, I'll ask it. Otherwise, it's all show. Everyone kind of knows the arguments, and you listen to the arguments, and the lawyers make their case, and I don't really need to ask questions.
I understand his position. I think as an observer of the court and having practiced law for 38 years now, I view it differently. I have found that the give and take, whether it's at a trial court or in an appeal, the give and take with the court, certainly from the lawyer standpoint, and I think from the court standpoint, is a very helpful exercise, because there are nuances, McGraw, no matter how well someone writes, how well someone tries to get in the mind of the court as to what they're thinking, we always don't think of something, and that will come out at oral argument.
What are your thoughts on this case? First of all, they're going to release it when? In June, July? When do they?
I think they go on recess at the end of June, and absent something extraordinary, which I don't think will happen here, we will have an answer by the end of June as to the Trinity Lutheran case.
You want to make a prediction?
I think the court will apply a rational basis test and will uphold on very narrow grounds the Missouri constitutional limitation.
And we should say that we were talking off the air, Josh Hawley, the newly minted Attorney General, getting praise for him recusing first himself and then the entire office for doing the right thing.
Isn't it refreshing to have a politician, McGraw, who stands up and does the right thing, irrespective of the politics?
Right.
Not only has he done the right thing once in initially recusing himself, he did the right thing again by, within the last 72 hours, recusing his entire office. So wherever you are on the political spectrum, far right, far left, or more moderate, Josh Hawley deserves a tip of the cap from the people of Missouri this week.
Ladies and gentlemen, that is worth 2.5 credits towards your law degree at St. Louis University Law School. Send your money directly to McGraw Millhaven here at the Big 550 KTRS. Greg Willard, thanks for coming in. Always good stuff.
Always good to be with you, my friend.
9:30.